Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. But today's story takes us to that great northern nation of Canada, in which a judge has ordered Jordan Peterson to engage in the Maoist struggle session because he has the wrong thing. So, to explain this to some people who may not know about Jordan Peterson, let me give you a very brief background about who Jordan Peterson is. Jordan Peterson is a clinical psychologist. He meets people in offices to, engage in therapy, or at least he used to before he became famous. He's been a clinical psychologist since 1999. He has taught at McGill University and at Harvard as well. And he has successfully taught many, many students in his classrooms, and videos of his classroom teachings are available on the YouTubes well before he became famous. So he was doing the online education before it was cool, or at least making his lectures available online before it was cool. So he has been a licensed psychologist since 1999. He rose to fame in 2017 as he testified against a then pending bill in Canada called C-16. Bill C-16 was a proposal to enshrine human rights status into gender identity and gender expression. So Canada has human rights laws, as you would perhaps expect, and there was a debate as to whether or not gender identity, gender conformity, whether gender should be a status that receives this human rights protection, whether people who are, say, they're trans, have human rights protection as a special protected status. Does being trans or other gender identity get special protected status? So Jordan Peterson testified against this bill in 2017, saying that, among other things, he thought that the proposal would require him to use other people's pronouns, that it would be a human rights violation if he didn't use other people's pronouns. He's like, but I don't agree with it. I don't think that's right. I don't think a person who's biologically male can just declare themselves to be a she, and no matter how much they might think that internally, it doesn't necessarily make it true. And it doesn't make it, and if I am forced to say it, then I'm violating my conscience over their human rights because you're forcing me. Everyone said he was ridiculous. It would never come to that. And fast forward a couple years, and now here we are. So Jordan Peterson, as a result of getting this notoriety from Bill C-16, then went on to launch his book, 12 Rules for Life, and his follow-on book, Beyond Order, both of which have been wildly successful. He has since engaged in a worldwide tour multiple times. I've seen him in person 3 different times, or 4 at this point. 4 times at this point I've seen him in person, and I've enjoyed his lectures every time I've been able to experience them. And he, of course, has appeared on many different podcasts, promotions, and other things as he's tried to get his message around. He's been a very notable person in the anti-woke based movement for a hot minute now. So he has been notable. So that's who Jordan Peterson is, for those of you who might not be familiar with him. He's incredibly well-known, incredibly popular, incredibly anti-woke person who doesn't want his language to be conformed. And perhaps my favorite interview with him has to be the interview he did with Kathy Newsom. So what you're saying is, no, we're not saying any of those things, Kathy, but that's okay. We'll try to educate you the hard way. Okay, so that's some background. So let's talk about where we are in terms of these things. Okay, so the College of Psychologists of Ontario, which is not an academic college. The College of Psychologists is the licensing organization for psychologists. It's the group of psychologists that does the licensing. So they call themselves a college, but in this particular sense, they are not a college in an academic sense. They don't do teaching and they don't do, education. They're a group of professionals. Okay, so the College of Psychologists of Ontario proposed that Jordan Peterson do the Maoist struggle session re-education camp because of the wrong thing. All right, that if he has to do the re-education and learn how to use the social media, even though he is by far and away have more social media experience than the entire rest of the college combined, like all the psychologists, by several orders of magnitude. Because, he's more well-known than all of them. But he has to undergo the re-education about how to use the social media. He objected to this. He objected to the College of Psychologists, saying that he had to undergo the the Maoist Re-Education Center. And so he went to the courts and said, courts, this order from the College of Psychologists is invalid. They're threatening me. They're threatening my license on improper basis, and I want you to get them to stop. Well, the court said no. I'm not going to make them stop. You have to do the re-education. All right, so that leads us to today's decision. In the case of, we are in Ontario in the Superior Court of Justice between Jordan Peterson, who is suing to prevent the college from acting on him, and the college who would like to discipline. This would be roughly equivalent to me suing like the state bar. That would be like the equivalent, right? The bar is coming after me, and I'm going to sue the bar, which, sometimes has happened before. People have sued the bar successfully before. I remember particularly when the state of Pennsylvania was trying to adopt this woke language in its own bar rules. I forget if he was already a lawyer, if he was a law student. I forget which way. He might have been already a lawyer, and he sued the state bar for trying to adopt Rule 8.4, and the courts agreed with him. So this would be the rough equivalent of me suing the bar. He has sued the College of Psychologists, and they have come up with this decision, so we're going to go and read this. This, you can see, was heard in Toronto on June the 21st of 2023, but the decision was issued today. All right, so let's read the court's decision for all of its glory. This is apparently from Judge Shabbos. Okay, Judge Shabbos, what you got for us? When individuals join a regulated provision, they do not lose their charter right to freedom of expression. At the same time, however, what was that Tyrion, was it Tyrion or who said on Game of Thrones, nothing before the word but matters? Yeah. At the same time, however, they take on obligations and must abide by the rules of their regulatory body that may limit their freedom of expression. So you don't lose your right of freedom of expression, but they can limit your right of freedom of expression. Which sounds to my ear kind of like the same thing, but okay. This case raises a clash between a regulated clinical psychologist's right to speak in a certain manner and the regulatory power to require the member to moderate that speech. So this is literally, can we force Peterson to not say the mean words we don't like? Does Peterson have First Amendment rights? Well, no, because it's Canada. The equivalent, does he have freedom of speech rights or doesn't he? Well, let's find out. The applicant, who is Dr. Jordan Peterson, seeks judicial review of a decision of the inquiries. Ooh, what a sort of Kafka-esque name. I like it. Decision of the inquiries, Complaints and Report Committee, the ICRAC of the College of Psychologists of Ontario, dated November 22nd, 2022. The decision in November ordered Dr. Peterson, as a registered member of the college, authorized to practice the clinical psychology, to complete specified continuing education or remedial program regarding professionalism. You were not professional enough, sir. We would like you to be more professional. We do not like the way that you're communicating. We do not like the way that you are speaking. We do not like it very much. We would like you to do a continuing education or remedial program, the Maoist struggle session, regarding your professionalism in your public statements. How fun. The ICRAC's order followed an investigation into language used by Dr. Peterson in public statements earlier in 2022. One will take note that these are not statements that he made in a licensed psychology session, right? That isn't the argument, right? These are arguments that he's making in the public, in a public way, before the public, right? So that would be the equivalent of me making statements, for example, on this YouTube channel, versus me making statements in my capacity as a lawyer before a court somewhere, right? If I'm in court, there's certain rules of conduct that govern those proceedings, but this is not in court or the equivalent. This is just out in public. So the college would like the ability to raise to reach into the public sphere. And incidentally, as I sort of alluded to earlier, the American Bar Association has tried this with lawyers too. There is a rule that prevents lawyers from discrimination as it relates to their practice inside an adjudicative process. That is to say, a trial, right? I'm not allowed to just be discriminatory inside that process, but that's only inside the process. The American Bar Association tried to promulgate a rule called 8.4G that would extend that to out-of-court proceedings, just any time. And as I mentioned, at least one court has already ruled it to be unconstitutional. Also, the Texas Attorney General thought it was unconstitutional. I think Vermont and New Mexico adopted it. It hasn't been super popular, but they are trying this stuff in the legal profession too. They're trying this stuff in the legal profession too. If you have the wrong think, no matter if it's on your own time, outside court, inside court, we don't care. You have to conform your language, or if you don't, you will take away your license. So that's kind of what we're doing here, right? So the statements in the public may be reasonably regarded by members of the public as those of the profession, and therefore as disgraceful, dishonorable, and or unprofessional. I like the rule of threes there. I notice I'm picking up what you're laying down. And post moderate risk of harm to the public. His statements in the public are proposing harm. Okay, the risk of harm identified by the ICRAC includes undermining public trust in the profession of psychology, which, if you know anything about Jordan Peterson and how well attended his lectures is and how popular he is, every time he goes anywhere, he sells out. He's incredibly popular. He fills 2,000, 3,000, 4,000 people stadiums without breaking a sweat. I suppose lecture hall is a better term than stadium, but you understand what I mean. Theaters. He fills huge theaters, 5,000 people theaters. The public goes to him. They listen to him. They listen to him intensely. They read his books. They listen to his podcasts. But the public might regard it as unprofessional. The public who is enamored to go see him time and time and time again, as I've seen him 4 times in public. Find it exciting. So the risk of harm apparently by the ICRAC includes undermining the public trust in the profession of psychology, which, no, I think the college is probably more on that bent right now than not, and also may raise questions about Dr. Peterson's ability to appropriately carry out his responsibilities as a registered psychologist. I don't know, man. He seems like he's doing pretty good to me. I'm not a licensed psychologist, but, you know, a lot of people seem to love him. The public seems to love him. His books have been immensely popular. They would have been on the New York Times list if the New York Times list had let them be on the list, which they didn't. They made an editorial decision to exclude them for some reason. Yeah. He's been incredibly popular, incredibly well-read, sold millions and millions of books. People listen to his every word, but they might bring the profession into disrepute. Okay. Although Dr. Peterson, in responding to the ICRAC's concerns, said he was taking his own steps to address his public statements, the ICRAC decision requires Dr. Peterson to participate in a coaching program. What a nice euphemism that is. Coaching program, just a little light coaching. Directed by the college to reflect on and ameliorate his professionalism in public statements. We just want you to be a little bit more reflective on being a professional. We just want you to be a little bit more professional in your communications. This is about the time that I, as a professional, want to flip the bird. Because I can, because I still have First Amendment rights. And the bar can eat me as it relates to my own time. Thank God. But apparently not so much in Peterson's world, right? He calls himself a psychologist, and it might bring the profession into disrepute. Uh-huh. Yeah, sure, okay. I'm sure that's a problem. It's not that, you don't like what he says and that he's incredibly, insanely popular. Uh-huh. All right. The judge, writing for themselves, writes, I have concluded that this application should be dismissed, so your lawsuit goes away. In my view, the decision of the ICRAC adequately and reasonably considered Dr. Peterson's statements in the context of the college's statutory mandate to regulate the profession in the public interest. Again, how this relates to his profession as a clinical psychologist, a little unclear, but okay. Is considered and proportionally balanced the impact of imposing this re-education program, which we're going to call a SCERP, which sounds about right. I'm gonna interpret SCERP as an onomatopoeia because I can. All right, so we want to give him the SCERP. Got to SCERP him. Great. On to Dr. Peterson's right to freedom of expression protected by the Canadian Charter of Rights and Freedoms. So I like how we're doing that, right? It's balanced against his rights in the freedom of expression. The court writes that the order is not disciplinary and does not prevent Dr. Peterson from expressing himself on controversial topics. Doesn't it? Doesn't it, though? Are you sure? Are you sure it doesn't? Because I'm not sure it doesn't. I think it might. It has minimal impact on his right to freedom of expression. Wait a second. Does it prevent him from expressing himself or not? It has minimal impact on his right of freedom of expression and meets the requirements of the Canadian Supreme Court's framework for balancing competing considerations set out in relevant case law. So apparently the Canadian Supreme Court is like, your rights are subject to being balanced with other people's fees. That's an interesting view of someone's rights. Further, in accordance with the Canadian Supreme Court's decision, in some case, the decision is transparent, logical, and provides a coherent chain of reasoning, and is reasonable based on the facts which were before the ICRAC. So, Dr. Peterson, please sign up for your malice struggle session. We would like it very much. All right. So the court would like to give you some background. Dr. Peterson has been registered with the college, which is to say he's been licensed by the licensing authority since 1999. However, he stopped seeing patients in 2017 and no longer has a clinical practice, which, one would think might stop the inquiry, right? He's not practicing as a clinical psychologist. So whatever he's doing now is not the practice of clinical psychology, much like what I'm doing right now is not the practice of law, right? I'm not before any court right now. I'm not representing a client right now, right? This is not the practice of law right now. So it is beyond the regulation of the bar because it is not the practice of law. I might be a lawyer. I might be bringing my legal education to bear, but it is not the practice of law because it's none of those things. And so one might think that might stop the inquiry because while he is a clinical psychologist, while he's licensed, he is not engaged in the practice of clinical psychology. So, that should satisfy the college's concerns, one would think, but apparently not so much. Rather, as his counsel describes him in their written statements, he is a prolific author, podcaster, and YouTube content promoter who maintains an active social media presence. In his social and political commentary, Dr. Peterson is often colorful and controversial. Yeah, but you have a right to be controversial because it's the right to think. Freedom of speech only has value to the extent it protects the controversial. You don't need freedom of speech to protect the controversial. You don't need freedom of speech or the First Amendment to protect things that are not controversial. If it's not controversial, you don't need the First Amendment. If it's not controversial, you don't need freedom of speech. Freedom of speech only has value to the extent it's controversial. That's kind of the point. Yeah. Nevertheless, Dr. Peterson maintains his membership in the college and refers himself in his public statements as a clinical psychologist because he is, much like I might refer myself as a lawyer because I am. Right. Yeah. Since at least 2018, the college has received complaints about Dr. Peterson's public statements. Some complaints have been formal, but many were tweeted to the college via social media and often involve Dr. Peterson's views on topics of social and political interest involving transgender questions, racism, overpopulation, and response to COVID-19. Oh my God, Dr. Peterson had the wrong think about COVID. Well, we can't allow that to be true, right? We can't allow the wrong think on the COVID. That might be the worst thing of all. It's also notable that I'm not sure that any of the complaints came from former patients of Peterson. This is a little bit like, for example, just by way of comparison, to our good friend Nick the Ricada, or Nick the Nose Ricada, I suppose we should say, who has been from time to time the subject of bar complaints by just people in the public who don't like what he has to say. It's not his clients that are complaining. It's just randos who are like, I don't like what Nick Ricada says. Shut him up. And the bar, to their credit, has said, go away and piss in a stream somewhere because we're not doing this. Right? I mean, they're not coming from anyone who has an interest or standing. Are you a former client? Are you upset about how he treated you as a client? Do you think he's done you wrong as a doctor? What is your standing exactly to be raised here, right? What is your belief? It's just, oh, I don't like the things. So it's just from randos, but apparently randos is good enough in Canada, I guess. In March of 2020, following an investigation of statements made by Dr. Peterson, which were alleged to be transphobic, sexist, racist, and were not in keeping with any clinical understanding of mental health, the ICRAC did not make any order regarding him. However, at the time, ICRAC expressed concern, a little bit of tone policing there, that the manner and tone in which Dr. Peterson espouses his public statements may reflect poorly on the profession of psychology. We're doing a little pearl clutching over here in ICRAC land. So we're not going to issue any formal statements, but we're going to be like, your tone, sir, your tone is not genteel and not that of a gentleman. Have you considered perhaps having a different tone? And right about now, I want to just raise the middle finger. Because, well, maybe a different tone would be good, but, I'm entitled to speak the way I want. So, how about go to hell? Yeah. The ICRAC noted the importance of a psychologist to conduct themselves in a respectful manner. Whether Dr. Peterson identifies himself as a psychologist or not. So apparently, this has nothing to do with the fact he calls himself a clinical psychologist, because they just told you it doesn't. So even if Dr. Peterson didn't call himself a clinical psychologist, I suppose his professional trade association, his guild, would still have an interest in his every waking moment. You're licensed by us. You're owned by us. I don't remember getting the tattoo embedded on my ass when I became a lawyer that said "property of the bar." I don't know if that's how they roll over there in Canada. And with that, maybe we need to look into that. But yeah. The ICRAC reminded Dr. Peterson of his responsibility to be cognizant of how his provocative language and tone might impact the public perception toward the profession of psychology, and that his public utterances may have negative consequences for those struggling with issues directly or tangentially related to his comments. Some people might not like his words. They might be upset by his words, and don't you know that upsetting people isn't what a clinical psychologist would do? Which, incidentally, not for nothing, but it might be what a clinical psychologist would do. Because maybe a swift kick in the ass is what the patient needs. Maybe upsetting the patient is the right course of action in the short term. Sometimes the doctor has to do something that's going to cause pain or hurt in the short term because we need to fix the problem. So just because the patient is crying, and just because they're in pain, and just because it hurts a lot, and just because it isn't what they want to hear, doesn't necessarily mean the doctor is doing it bad. Sometimes when the doctor has to fix something, it's going to be painful. But oh no, we can't have that because these people are dealing with issues and they're struggling, and they might be undermined in some way because they don't like what it's saying. And that's a problem over here in psychology land, I guess. The ICRAC concluded with what we're going to call advice, which is really more an admonition, but let's call it advice. As a registered member of the college and in light of your public profile, you may wish to offer your opinions and comments in a respectful tone in order to avoid a negative perception towards the profession of psychology. We are literally tone policing, people. We are literally tone policing. The problem is your tone. The problem is you said it with the wrong affect. How fun we are in Canada. Good times. Between January and June of 2022, the college, which again is not really a college in the academic sense, it's not a college in the academic sense, it is just a regulatory body. But they call themselves the college because, I don't know, that's how they roll in Canada. Yeah. The college received numerous reports about Dr. Peterson's conduct on the social media and in his public appearances. The reports again raised concerns about Dr. Peterson's professionalism, including whether his tweets complied with the college's standards of professional conduct. Now, I just want you to really fully contemplate that for a minute. Whether his tweets comply with the college's standards of professional conduct. This is what they were trying to do in the bar. This is what they were trying to do in Rule 8.4G. This is what they were trying to do, and most of the bar told them to go to hell because it's unconstitutional, as determined by many states, as determined by the federal courts in Pennsylvania. they determined it to be unconstitutional because we still have a First Amendment and we still take our First Amendment seriously, and thank God for that. But over here, the college, which regulates the licensed professions of the clinical psychologists, are like your tweets, though. Literally, your tweets are the problem. Okie dokie, the tweets and statements at issue included apparently the following. A tweet on January the 2nd of 2022 in which Dr. Peterson responded to an individual who expressed concern about overpopulation by saying, "You're free to leave at any point." Wow. What scurrilous words. What fighting and charged words. What words that cut to the core. I've had my entire perspective reevaluated, people. I thought I was in favor of freedom of speech, but man, oh man, I read these words and I have to agree with the college. Man, these words cannot stand, sir. They are beyond the pale. The First Amendment and freedom of expression have gone too far. In response to someone who said, "I'm concerned about overpopulation," he said, "I can't believe I have to repeat the words, so please make sure no children are present." Because this is, and also maybe get the women out of the room too. Although that's sexist, but still, this is only for the sturdy men. Only the sturdiest of men can hear this language. Dr. Peterson apparently said, "You're free to leave at any point." Truly, this must be stopped. Okay. Various comments Dr. Peterson made on January the 25th, 2022, appearance on the podcast, The Joe Rogan Experience. I don't know why, but I find it particularly amusing that we're using the Joe Rogan Experience against him. That strikes me as particularly funny. Yeah. Dr. Peterson is identified as a clinical psychologist, which incidentally you told me earlier doesn't matter, but whatever, and spoke about a vindictive client whose complaint about him was a pack of lies. Speaking about air pollution and child death, Dr. Peterson said, "It's just poor children, and the world has too many poor on it anyway." Okay, do you understand that he didn't mean that literally? You are so disingenuous. It is beyond, he didn't really mean it's just poor children, and the world has too many poor people in it anyway. I can't believe I have to explain this, but he was pointing out how people who want to regulate climate change, the people who are arguably the greatest contributors to the climate change are poor countries, because poor countries and poor people have the most inefficient fuel. They're wood burning or coal burning or dung burning because that's the amount of fuel that they have. And so he was just pointing out that the climate people who want to regulate the climate are just basically condemning poor people to further poverty because he wants to take away their ability to grow and develop into an economic engine. He wasn't really calling for poor people and poor children to die. I mean, could you straw man the man anymore? I literally just take his words. It's taking his words out of any possible context and just literally the words on the page. It reminds me of someone who takes a comedian's words and just the comedian's words as they flatly sit, with no nuance, and be like, "I can't believe the comedian said X." It's like, you don't understand how comedy works, right? It's like, if you take away all the nuance, if you take away all the delivery and just have the flat words, "Well, I can't believe the comedian said this horrible, horrible thing." He was being ironic and sarcastic. You guys are idiots. Apparently also problematic, a tweet on February the 7th of 2022 in which Dr. Peterson referred to Gerald Butts as a prick. Wow. I guess prick is truly beyond the pale for a Canadian. I guess prick is beyond the pale. This must not stand. This is Canadian hate speech, people. Okay. Number D. A tweet on February the 19th of 2022 in which Dr. Peterson commented that Catherine McKenney, an Ottawa city councillor who uses they, them pronouns, was an appalling, self-righteous, moralizing thing. Wow. Wow. These words are just so incredibly vile. I mean, when you come into this joking, you come into this ready to condemn everything, and man, oh man, you just read these words, and you're like, wow, I had no idea it was this bad. I was so wrong. I was so wrong for judging the college, man. Dr. Peterson deserves to be punished. These words, my friends, these words are not befitting a professional, nay, a human being. These words are so vile, so reprehensible. They must be stopped. He called someone a prick, and he called someone an appalling, self-righteous, moralizing thing. Wow. I'm shooken, sir. I am shooken. I am shooken on levels. In response to letter E, in response to a tweet about the actor Elliot Page being proud to include a trans character on a TV show, Dr. Peterson tweeted on June the 22nd, 2022, "Remember when pride was a sin? And Elliot Page just had her breast removed by a criminal physician." Wow. Remember when pride was a sin? Wow. Letter F. A further complaint about Dr. Peterson's January the 2nd, 2022 tweet, in which Dr. Peterson responded to an individual who expressed concern about overpopulation by saying, "You're free to leave at any point." So it's the same complaint again. So it's the same exact comment. We just received a second complaint about it. So we're going to list it second time. I'd note that that's double jeopardy at this point, but no one cares. Because it's literally the same conduct. It's just now you have two complainants instead of one. But we're going to list it twice, like it's two different things. So apparently Canada doesn't believe in the concept of double jeopardy, I guess. So it's a different offense now because someone else made the complaint. Okie dokie. Letter G. Dr. Peterson's tweet posted in May of 2022, in which he commented on a Sports Illustrated swimsuit edition cover with a plus-size model, tweeting, and again, I know before I even read it, we're going to have to steel our resolve. So I haven't seen the words yet, but please steel your resolve with me as I have to unfortunately use the vile language so that we all understand clearly what we're talking about. These are not my words. I am sorry to have to use them. But here's what he said. Quote, "Sorry, not beautiful. And no amount of authoritarian tolerance is going to change that." Wow. He said that the cover model on the Sports Illustrated was not beautiful. Wow. Wow. They say beauty is in the eye of the beholder, but apparently not in this case, because it is the wrong thing to think this person is not beautiful. One might think that beauty is subject to a person's taste. But no. In this particular case, the idea that this person is not beautiful is a human rights violation. Okie dokie. That's going over super well over here in Canada. The judge is really, really selling me at this point. The judge is super duper selling me on the idea that Jordan Peterson needs massive re-education. How could he possibly say these incredibly vile, horrible things? How could he possibly say the cover model on Sports Illustrated is not beautiful? Okay, great. Dr. Peterson identified himself on Twitter as a clinical psychologist in 2022. Not that it matters, by the way, because you yourself earlier said it doesn't matter. whether he identified himself or not. Remember, that's what you said earlier. So why are you mentioning that he mentions it? Because it doesn't matter either way. Does it matter or doesn't it? Take a side. This appears to be a change from 2020, when although he was a member of the college, he stated that he opted not to advertise his title on Twitter. So he changed his mind. In 2020, he opted not to identify himself as a psychologist. And in 2022, he said, yeah, I'm going to identify myself that way. Okie dokie. On March the 8th of 2022, the registrar of the college requested an appointment of an investigator. The report of the investigator was completed and provided to a panel of the ICRAC. The report was then provided to Peterson, who responded to it on July 21st of 2022. In July of 2022, the college was made aware that Dr. Peterson's Twitter account had been suspended as a result of Elliot Page comments, which had been flagged for violating Twitter's rules against hateful conduct. Dr. Peterson provided further response to the college in July of 2022. So, Twitter, which is a private institution, suspended Peterson because they said that pride was a sin. And yeah. And the college is apparently aware of this and using the actions of Twitter as evidence against him, I guess. Okay. On July the 27th of 2022, the panel released decisions recommending no further action be taken regarding Dr. Peterson's tweet, which he alleged to encourage people to commit suicide. You're free to leave at any point. Wow. That apparently is encouraging suicide. You're free to leave at any point is encouragement of suicide. Wow. That's great. Finding that while provocative and inflammatory, it could be interpreted as an innuendo, joke, or parody, and didn't rise to the level of disgraceful, dishonorable, or unprofessional. Could be interpreted as an innuendo, joke, or parody. Well, they hypothetically recognize that such a thing is possible, at least, so that's nice. Additionally, a tweet critical of the involvement of Children's Aid Society in removing children from the Ottawa trucker protest was also found to require no further action. However, on August the 4th of 2022, the college, which again is the regulatory body in this case for psychologists, wrote to Dr. Peterson on behalf of the same panel of the ICRAC about the remaining statements. The lawyer reviewed the statements, Dr. Peterson's self-identification as a clinical psychologist on his Twitter page and on the Joe Rogan podcast, and raised concerns that his statements might be demeaning, degrading, and unprofessional. It referred to and quoted from several provisions in the college's code of conduct. The letter observed the panel recognizes Dr. Peterson's right of freedom of expression, but has concern about the significant impact risks in this case, given that the public statements that are demeaning, degrading, and unprofessional may cause harm both to people they're directed at and to impacted and other members more broadly. You have a right to freedom of expression, but you totally don't. Okay. The panel noted the advice provided in 2020 in concluding that recurrent risk of Dr. Peterson using unprofessional language in the future was moderate. The panel proposed Dr. Peterson undertake to reflect upon these issues with a period of coaching, with a person selected by it as a remedial step. So apparently he's going to get himself a guru appointed by the college to help guide him along the path so that he will be able to conform his language with a more, should we say, a more bright affect. Let's call it that. This is fun shit. On September the 6th of 2022, Dr. Peterson rejected the proposal. I wasn't really looking for a guru in my life, and also not one appointed by you. In a lengthy letter to the college, Dr. Peterson acknowledged that the various social media platforms he utilizes requires careful attention to care and use appropriately, and they already implemented a solution in response to the college's concerns, which included modification of the tone of my approach. Dr. Peterson said he had surrounded himself with people to help him monitor his public communications and provide him with continual feedback as to the appropriateness of tone and content of what I'm purveying. And my response right about now would be the middle finger, but apparently that's not the way Dr. Peterson tried to deal with this problem, which, I respect him and his ability to make his choices the way he does. So he apparently thought, okay, I'm going to try to say I've already taken steps, which I'm going to assume that they are going to say is an acknowledgement of guilt. Right? The fact that I've taken steps is an acknowledgement of guilt. Great. These people include, Dr. Peterson said, his expert editorial team at Penguin Random House, which publishes his book, members of an immediate family who work professionally with me, and a very wide network of expert thinkers from the world of theology, psychology, politics, and business. Dr. Peterson concluded by writing, I would say that, then, in my defense, that I've already undertaken the remuneration of my actions in a manner very much akin to what's been suggested by the ICRAC, and have done so in an exceptionally thorough and equally exceptionally public and transparent manner, and therefore to submit to the ICRAC, I've already and plan to continue to atone for no doubt my multiplicity of sins in relation to my interaction with public audiences I have the privilege to serve. I can feel the sarcasm dripping off the page. I can feel the sarcasm dripping off the page. I'm not sure whether or not the college gets it, but I get it. Dr. Peterson also addressed the concern that he identifies himself as a clinical psychologist by writing, while the notoriety and complexity that's surrounded me since 2016 has made it impossible for me to retain my clinical practice at the standards of practice I regard as crucial, I remain a clinical psychologist and indeed a professor emeritus at the University of Toronto. I am functioning in the broad public space as both and appear by their testimony and actions to be helping millions of people. Given that I'm still licensed and still practicing in a more diffuse and broad manner, I think it's appropriate for me to identify myself as a psychologist. So, a very professional FU, which I appreciate. On September the 13th of 2022, the college staff responded on behalf of the ICRAC. The panel considered Dr. Peterson's position he was able to remunerate his conduct through the use of his own advisors. These advisors, the panel said, were not independent, and the review of his communications would not be from the point of view of the protection of the public interest, nor does it appear to offer any accountability or oversight to the college. As the letter continued, none of your experts you employ appear to be reviewing your communications through the lens of your obligation as a member of the college to uphold the standards of professional conduct and the Canadian Code of Ethics for Psychologists. We reject your experts as not being sufficient. Accordingly, the ICRAC stated its concern was recurrence risk in this case is high, and the plan you've proposed in your response does not adequately remunerate the risk. The ICRAC again proposed Dr. Peterson undertake a period of coaching by an independent professional and provide him with the name of two individuals who have experience working with regulatory bodies and with members of the college to remunerate the issues through the lens of professionalism and public protection. You will make sure to use our people because only our people will know how to properly coach you into the proper use of your communications. Great. In a subsequent letter responding to Dr. Peterson's counsel on October the 7th of 2022, the college referred to the competing interests of Dr. Peterson's right of freedom of expression and his obligations as a regulated professional, stating, the panel in no way disagrees that the Canadian Charter of Rights and Freedoms guarantees Dr. Peterson a right of freedom of expression. However, the panel in no way disagrees that the Canadian Charter of Rights and Freedoms guarantees Dr. Peterson a right of freedom of expression. However, the panel believes that as a member of the College of Psychologists of Ontario, Dr. Peterson also owes a duty to the public and to the profession to conduct himself in a way that's consistent with professional standards and ethics. The panel does not believe that Dr. Peterson's public statements are currently within line of professional standards and ethics. The proposed undertaking, which is capital U for some reason, okay. Are we using the word undertaking as a proper noun now? I guess it must be. The proposed proper noun undertaking would provide Dr. Peterson with the opportunity to better understand the standards and ethical obligations for regulated health professionals who make public statements of various kinds. On October the 21st of 2022, Dr. Peterson, through counsel, declined to sign the undertaking, stating that he's prepared to vigorously defend his right of freedom of expression, which the college has acknowledged are a factor. They did, but then they said, however. So. The ICRAC released its decision and reasons on November the 22nd of 2022. The ICRAC found that Dr. Peterson appeared to engage in degrading comments about a former client and make demeaning jokes. Oh my God. His jokes were demeaning. Dude, have you ever heard of such a thing? Have you ever heard of a comedian who is demeaning in their humor? I've never heard of such a thing ever. I mean, how would Dr. Peterson think? Why would he think it's possibly appropriate to be demeaning in comedy? It expressed a concern that by referring to Elliot Page as her, and by their former name, and by calling Catherine McKenney an appalling, self-righteous, moralizing thing, Dr. Peterson may be engaging in degrading, demeaning, and unprofessional conduct. So apparently, the dead name thing and her was too much. An appalling, self-righteous, moralizing thing is a degrading, demeaning, and unprofessional comments. Can I just say that Canada has a very, very low tolerance for degrading, demeaning, and unprofessional? I mean, they have a very low tolerance for degrading, demeaning, and unprofessional. I hope they never meet Nick Rackets. Woof. Woof. The panel also stated that referring to a physician who performed Elliot Page's surgery as a criminal appears to be inflammatory and unprofessional. In the alternative, it's a statement of opinion. But, whatever. Following reference to Gerald Butts and Sports Illustrated comments, the panel said it's very concerning that looked at cumulatively, these public statements may be reasonably regarded by members of the profession as disgraceful, dishonorable, or unprofessional. Okay, we literally have gone to the point where I'm not sure I can parody this thing anymore. I think we've gotten to the point where I can't parody this thing anymore. Because the truth is just so absurd, I'm not sure where there's left to go to parody it. We are literally using the fact that we said that the woman who was on the cover of Sports Illustrated was not beautiful as a basis for saying that he's engaged in disgraceful, dishonorable, and unprofessional statements. Apparently, that beauty is in the eye of the beholder thing is such an anathema, is such a, what would you go? One step further. It's haram. It's haram, don't you know? It is so unacceptable. It is an affront to the. It is an affront to the order as established by the good people of the college. Wow, we're having fun. This is so stupid. This is so stupid. He called Elliot Page a her. He used her former name. He called Catherine McKenney an appalling, self-righteous, moral thing. He said that Gerald Butts was not beautiful. Looked at cumulatively, these statements may be reasonably regarded by members of the public as disgraceful, dishonorable, and unprofessional. What members of the public are you talking about? What members of the public are these? Disgraceful? Saying a woman isn't beautiful is disgraceful? It's dishonorable? What the actual F? What the... this paragraph is blowing my mind. might need to read it again just because of how crazy it is. This is their conclusionary thesis over here. This is insane. I'm going to reread the entire paragraph. This is cray-cray. The ICRAC found Dr. Peterson appeared to be engaging in degrading comments about a former client and making demeaning jokes on the Joe Rogan Experience. It expressed concern that by referring to Elliot Page as her and by their former name, and by calling Catherine McKinney an appalling self-righteous moralizing thing, Dr. Peterson may be engaging in degrading, demeaning, and unprofessional comments. The panel also stated that by referring to the physician who performed Elliot Page's surgery as criminal appears to be inflammatory and unprofessional. Following reference to Gerald Butts and Sports Illustrated comments, where he said that she wasn't beautiful, the panel stated it is very concerned that looked at cumulatively, these public statements may be reasonably regarded by members of the public as disgraceful, dishonorable, or unprofessional. Wow. Wow. I smile at the absurdity. If you're wondering why I have this complete shit-eating grin on my face right now, it's because it's so absurd, I think it must be a joke. Because it's ridiculous. And it's like, okay, this is apparently the direction we're going. The ICRAC continues. The ICRAC continues by saying, quote, the panel is concerned that making public statements that may be inconsistent with professional standards, policies, and ethics currently adopted by the college poses moderate risk of harm to the public. These potential harms include undermining public trust in the profession of psychology and trust in the college's ability to regulate the profession in the public interest. Public statements of this nature may also raise questions about Dr. Peterson's ability to appropriately carry out his responsibilities as a registered psychologist. While Dr. Peterson may not currently have an active clinical practice, which, one would think we could stop writing at this point, but apparently not, he continues to be registered and authorized to do so. Further, public statements that are demeaning, degrading, and unprofessional may cause harm both to the people they're directed at and to the impacted and other communities more broadly. I will note at this point that the judge is citing this with approval. Oh, okay. I mean, you would think this is the point where the judge will then transition into, okay, this is a whole bunch of bullshit and you're absolutely insane. And I can't believe this bullshit you wrote, and you should be ashamed of yourselves. Sit in the corner with your shame, right? You would think this would be the part of the exercise where the judge is about to, any second, transition into the, well, that was a whole bunch of bullshit and a total waste of our time. We're all a lot dumber for having heard of it, part of the opinion. But sadly, that part is not going to come. Sadly, we're not going to get the, we're all stupid for having heard it, part of the discussion. Because the judge thinks this is A-okay. Super duper. Continuing on with the judge's explanation of their reasoning, the panel also said it was very concerned about recurrent risk and where it describes as high. In support of this conclusion, the panel referred to advice Dr. Peterson received in 2020, which that word advice, I suppose, was a little bit more nefarious. When we said advice, we meant more in the sense of directive. It wasn't really advice so much as it was a command. But you didn't take the hint. It was advice in the same sense the mafia, it tells you it would be a shame if anything happened to your store. It wasn't just a friendly comment of concern. It was a threat. Okay. The lack of independent advisors who could review his communication through a lens of obligation as a member of college. By the way, at this point, I'd like to volunteer to be an independent advisor because I'm well independent of the college and the entire country of Canada, and more than happy to give independent advice. So God, just call me. And that Dr. Peterson did not appear to acknowledge any of the panel's concerns. The panel then set out the terms of the SCRP, which is the forced re-education plan we mentioned earlier. That would be the Malice struggle session with the re-education and re-indoctrination. The SCRP. It directed that Dr. Peterson enter what we're going to call a coaching program with either one of two individuals identified by the panel to review, reflect on, and ameliorate his professionalism in public statements. Okay. The coaching program was to begin within 3 months and complete within 12 months. Costs associated with the coaching were to be borne by Dr. Peterson. So go to the coach. They're going to give you a little conversation, a little chat, so that you take the hint. The panel also stated that failure to comply with the mandatory re-education program, otherwise known as the SCRP, may result in an allegation of professional misconduct. And then unless the coach provided a final report indicating the concerns have been appropriately remediated in the public interest, Dr. Peterson will not be considered to have successfully complied with the SCRP, which may constitute professional misconduct. So our advice has turned into a directive, and if you don't do it and the coach doesn't agree that you have been successfully re-indoctrinated, we are going to hold it against you professionally. And presumably try to take away your license. Great. It's going great. It's going great. All right. The issue in this case is whether the panel's decision to order Dr. Peterson to complete the SCRP was reasonable. Dr. Peterson raises two arguments which he submits make the decision unreasonable. That the ICRAC failed to conduct an appropriate proportionality-focused balancing of Dr. Peterson's right of freedom of expression and statutory objectives of the college as required by the Supreme Court of Canada. And the decision fails to meet the standard of justification, transparency, and intelligibility required by the Supreme Court decision of Canada, and is unreasonable having regard to the facts and legal rights at stake. There is no dispute that the standard of review is reasonableness, and principles set forth out in the case law must apply regarding the decision. So apparently, it will be valid as long as it's reasonable. Is this a reasonable balancing of rights? Which I don't know what that means in Canada. But if this were U.S. law, which isn't that far off Canada law, so I'm going to guess it's the same. Reasonable goes a long way. Reasonable goes a long way, right? That's typically the kind of standard we talk about for everyday normal governmental action. Reasonable, rational, rationally related to a legitimate governmental objective. Is it rationally related to a legitimate governmental objective? Any of them will be fine. That's reasonable. Reasonable goes a long way. So it sounds to my American ear, like we're trying to overcome rational basis review. It sounds to my American ear like in order for me as a court to overturn this, I have to say that they did not undergo reasonableness within the meanings of a rational basis review. Do you know how fucking hard that is? Do you know how fucking hard it is for the government to fuck up rational basis review? It's really fucking hard. It's really fucking hard. It's about as hard as it is for the government to meet strict scrutiny. Right? It's basically impossible. I've seen it done. I have seen it done. I have seen the government fuck it up so much that it does not meet rational basis review. But you have to try pretty hard. Because it doesn't even have to be a reason the government stated. It doesn't have to be a reason the government came up with. Any reason will do. anything will be fine. Any reasonably related thing to any rational objective of any legitimate exercise of power. So if that's the standard, well, I already know how this decision is going to end. Especially because apparently in our rational basis review in Canada, I'm allowed to explicitly balance someone's fundamental right to freedom of speech against other considerations. So apparently in this rational basis review, I'm like, the equivalent would be, well, the First Amendment is interesting and all, but if you consider the fee-fees of the other person, your First Amendment right's important and all, but, fee-fees. And so I'm now going to balance your First Amendment rights to speak. Yeah, okay, that's apparently what we mean by rational basis review. It's going great. Okay. In a case, the Supreme Court of Canada addressed the question about how to protect the Charter's guarantees, which I'd say are like our Bill of Rights, but apparently are not. And the values they reflect in the context of adjudicative administrative decisions. As the court has elaborated, the framework is concerned with ensuring the Charter protections are upheld to their fullest extent possible, given oh, Lord. Is concerned with ensuring the Charter's protections are upheld to their fullest, given statutory objectives. So, that would be like me using a statute to overrule the Constitution of the United States. I mean, I know you have a First Amendment right and all, but did you consider that the legislature passed a statute that says you don't? Did you consider that? Okay. This requires, and it's even worse than that, by the way, because it's not even the legislature. It's some administrative bureaucrat somewhere. So this is like taking Chevron and notching it up to 11. I thought I hated Chevron deference already. I didn't know I hated it this much, because apparently in Canada, it's like, yeah, you have that First Amendment right. That's really important. But did you consider the fact that an administrative agency says that you don't? Did you consider that? As part of the, we give all possible deference to the administrative agency. That administrative agency says you don't have a First Amendment. So, Chevron. Okay, great. Or apparently, as we're going to call it, the Law Society of British Columbia versus Trinity. So apparently their Chevron is called Trinity or something. Which sounds about right, because either way we're setting off a nuke. This requires an administrative decision maker, such as the ICRAC, to proportionally balance those rights. Oh, okay. Balance in proportion. Okay. I'm having some bad flashbacks to some Justice Stevens opinions right about now. This is highly contextual inquiry. A decision maker must first consider the statutory objectives it's seeking to uphold, and then secondarily ask how the Charter's values at issue will best be protected in the view of the statutory objectives. Okay, great. This requires conducting a proportionality exercise, balancing the severity of the inference, or interference rather, of the Charter right with the statutory objective. However, as proportionality test under Section 1 of the Charter, which will be met if the measure falls within a range of reasonable alternatives, in the context of a review of administrative decision for reasonableness, decision makers are entitled to a measure of deference so long as the decision falls within a range of possible acceptable outcomes. This sounds suspiciously like Chevron. This sounds very Chevron-esque. I'm having bad Chevron flashbacks right now. Except now it's an administrative agency that's balancing my First Amendment rights. That's great. The Supreme Court of Canada elaborated on the framework in some case called Loyola's High School versus Quebec and Trinity Western, observing that the approach is not a watered-down version of proportionality, but is to be robust. So it's robust proportionality? Okay. On application for judicial review, therefore, the role of the court is to ensure the administrative decision maker proportionally balance the impact of, your fundamental rights and the statutory objectives, which gives effect as full as possible to the charter rights at stake given the particular statutory mandate. As the court stated, put another way, the charter's protection must be affected as little as reasonably possible. As little as reasonably possible in light of applicable statutory definitions. When a decision engages the charter, reasonableness and proportionality become synonymous. Simply put, a decision that has disproportionate impact is not reasonable. So as long as the balance of the scales, are 51-49, I guess your rights are not that important. Okie dokie. However, it's also clear that the approach still requires deference. A reviewing court need not agree with the outcome, as that would impose a standard of correctness. So I, as the court, don't have to agree the administrator was correct. Rather, the question is always whether the decision falls within a range of reasonable outcomes. So not would I balance the scales that way, but could a reasonable person balance the scales that way? This is like clear error review by a court of appeals, kind of. That's what we're doing, right? That's kind of what this is. This is clear error review by other means. This is clear error review. Okay, I'm a court of appeals reviewing a decision from a trial court. The trial court has made a finding of facts. I'm not supposed to reverse those finding of facts unless clear error. Or the trial court made a decision. The trial court made a decision to bring in some witness or exclude some witness. I'm not supposed to reverse that decision unless it's an abuse of discretion. Right? So it's not, I as the appellate court am not supposed to say what I would do. Would I allow that witness to testify or not? Would I have excluded that piece of evidence or not? Would I have reached that finding of fact or not? That's not the right question. That's not the right question because deference, clear error, abuse of discretion, right? The question isn't would I have done that, but could a reasonable judge have done it? And if it sounds hard to overturn, it's because it is. It's supposed to be hard. So that's kind of what they're talking about. That's what the analogies that are making sense in my mind are talking about, right? So it's not important that I agree with it, nor must a decision maker choose the option that limits the protection the least, which incidentally, they would have to do in the United States because that's the strict scrutiny test. That's strict scrutiny. You literally have to choose the option that would inhibit it the least. If you're going to pass strict scrutiny, which good effing luck, but if you're going to, you literally have to choose the option that would be the least infringing. So if I, the government, want to restrict your First Amendment rights, first of all, I have to have a compelling governmental interest. So not just legitimate, not just important, but compelling, right? Not just legitimate, not just important, compelling. And I have to choose the least restrictive means. I literally have to pick the option that will infringe your rights the very least. And maybe I might pass strict scrutiny review, but apparently not so much here. So the decision maker doesn't need to do that. Least restrictive means just needs to be proportional, man. Least restrictive. Yeah, you could have done this in a lesser restrictive way, but it's fine. I mean, it's only your fundamental rights, the fact that you could have done it less restrictive and still accomplish the goal, it's fine. Okay. If in exercising its discretion, the decision maker has properly balanced the value with the objectives, it will be found to be reasonable. Least restrictive means, what's that? Never heard of it. Narrowly tailored. Never heard of it. Is it in balance? Coulda, it's a 50-50 call. 50-50 call. Anything's fine. Any sort of thing is fine. Wow. I sense Canada really takes those charter rights super duper seriously. Super duper seriously. I could see how seriously they take those charter rights right about now. Wow. The case law does not change the standard of review, which remains clearly a test of reasonableness, showing deference to and respect for the decision maker's specialized expertise. So it's Chevron. It's Chevron. The administrative agency has spoken. Although it's worse than that because, as I mentioned, it's Chevron with proportionality. So, that whole we get to infringe your First Amendment because, it's proportional thing. So it's Chevron with, it's even worse. Rather, the case law focuses on reviewing courts on the decision actually made by the decision maker, including both the decision maker's reasoning process and the outcome. As the court has noted, the role of the courts in these circumstances is to review. They are, as a general rule, to refrain from deciding the issue themselves. Great. Accordingly, a court applying the reasonableness standard does not ask what decision it would have made in the place of the administrator, attempting to ascertain the range of possible conclusions that would have been open to the decision maker, conduct a de novo analysis, or seek to determine the correct solution. It's not for me to decide. What am I, a court? It's not for me to decide. It's for the administrator to decide. I'm just here to review. I don't have to figure out what the correct answer is. I just have to figure out whether their option was a correct answer. A reasonable decision, as we're told in the case law, is one based on internal cohesion and rational chain of analysis that's justified in relation to facts and law that constrain the decision maker. However, reasons must not be assessed against a standard of perfection. They need not include all arguments, nor should they always be expected to deploy the same range of legal techniques that might be expected of a lawyer or a judge. As the Supreme Court of Canada has put it, administrative justice will not always look like a judicial justice, and reviewing courts must remain acutely aware. So that administrative judge, man, they might not be doing what a judge would do, but it's totally fine. No problem. It's all fine by me. Wow. Right about now, I wonder if the United States should offer Jordan Peterson asylum. Probably not from the Biden administration. Yeah, we need a Republican Congress. We need a Republican Congress at this point, so we can pass a private bill and give Jordan Peterson citizenship. That'd be good. And we give him asylum from the evils of Canada. Because apparently administrative justice is totally fine by an administrator who's just supposed to balance things out. And, they may not be doing things in a way that, is fundamentally respectful or the narrowest tailored way, but, it's totally fine. It's totally fine. Yeah. Let's put forward a private bill. Reasons must be read in light of history and context of the proceeding which they're rendered, including evidence and submission of the parties. As the court has noted, this may explain an aspect of the decision maker's reasoning process that's not apparent from the reasoning themselves, or may reveal an apparent shortcoming in reasons that's not in fact a failure of justification. Wow, that's even worse. So actually we're supposed to back end the reasoning. So even if you read the administrator's decision and be like, that's full of shit, you're not done. That's basically what that means, right? Even if you read the administrator's findings and you're like, that's full of shit, you're not done. Basically, you have to go back and you have to figure out whether or not there's any way they could have come up with a decision. This sounds very, very deferential. Further, the degree of justification found in reasons like reasonableness review itself must reflect the stakes. As the court has said, when the impact on a decision on an individual rights and interests is severe, the reasons provided to the individual must reflect the stakes. The principle of responsive justification means if a decision is particularly harsh consequences, the decision maker must explain why decisions best reflect the legislative decision. This includes decisions with consequences that threaten an individual's life, liberty, dignity, or livelihood. So if it's just a little tiny violation of your rights, I guess it doesn't matter very much. Super duper. The court, writing for themselves, says, in my view, the ICRAC conducted inappropriate, proportionality-focused balancing of Dr. Peterson's right of freedom of expression and statutory objectives of the college. You know what? Actually, given the court standards, I'm not even sure I can chide the court. If the court is accurately stating the law, and I have no reason to believe they're not, the court isn't wrong. Which speaks more to how fucked up Canada is than this court, right? I'm not sure the court's wrong. If these are the correct standards, if they're quoting the case law correctly, and I have no reason to believe they're not, then the court's judgment is correct. Which speaks more to a fundamental concern about how Canada considers its fundamental rights than this court's decision. I'm not sure Canadian justice on civil law would be able to render any decision other than this. That's how messed up this is. The court's probably right. Canada just doesn't take its rights very seriously, but the Canadian Supreme Court has told them not to. So, you know, what can you do? But be like, well, I guess those rights aren't really important after all. I'm just a lowly trial judge. The Canadian Supreme Court has told me that the Canadian Charter of Rights is basically a bunch of bullshit. It's a parchment guarantee that doesn't mean very much. What am I supposed to do about it? Wow. Wow. Consistent with the case law, the ICRAC approached the matter from the perspective first of fulfilling the college statutory mandate to regulate the practice of psychology in the public interest. This included considering the conduct of Dr. Peterson in the light possible of risks to the public, and then considered how to balance the statutory objectives in order to minimize any impact on his charter rights. Wow. This is just special on every possible level. Following a review of background and specific complaints about Dr. Peterson's conduct, the ICRAC referred to the Canadian Code of Ethics of Psychologists. The code had been adopted by the college and incorporated into the college's standards of professional conduct. The code had been adopted by the college and incorporated into the college's standards, and states that information provided to the public must be consistent with professional standards, policies, and ethics currently adopted by the college. As a registered member of the college, Dr. Peterson is obligated to follow the code and standards. The ICRAC identified sections of the code relevant to Dr. Peterson's public statements. The panel considered Principle 1, respect for the dignity of persons and people. This includes the statement that respect for the dignity of persons is most fundamental and universally found ethical principle across disciplines, and includes concepts of equal inherent worth, non-discrimination, moral rights, and distributive, social, and natural justice. The code continues, in respecting dignity, psychologists acknowledge that each human being should be treated primarily as a person, or an end in himself, not as an object or means to an end, and as worthy of equal moral consideration. In doing so, psychologists acknowledge that all human beings have a moral right to have their innate worth as human beings appreciated, and this inherent worth is not dependent on a human being's culture, nationality, ethnicity, color, race, religion, sex, gender, marital status, sexual orientation, physical or mental ability, age, social economic status, or any other preference or personal characteristics, condition, or status. Okay. As such, psychologists do not engage in unjust discrimination based on factors and promote non-discrimination in all their activities. I have a question. I have a pretty notable question. It says psychologists, among other things, acknowledge that human beings have a moral right to be appreciated, and this inherent worth includes, among other things, mental abilities. At that point, what is there left for psychologists to do? If psychologists must acknowledge that human beings have a moral right to innate worth that is not dependent on their mental abilities, What's left for psychology? Okay. All right. Consequently, the code states that the requirement that members not engage publicly, for example, in public statements, presentations, research reports with primary clients or other contacts, in degrading comments about others, including demeaning jokes. They've literally outlawed jokes. It literally says that in the code. Wow. So I guess you literally can't be both a psychologist and a comedian at the same time. You can't do psychologist by day, stand-up comic by night, I guess. Okay. You are not allowed jokes based on characteristics as culture, nationality, ethnicity, color, race, religion, sex, gender, or sexual orientation. They literally illegalize jokes. Okay. The code also urges members to strive to use language that conveys respect for dignity of persons and peoples as much as possible in all spoken, written communication or print communication. The ICRAC panel considered the statements made by Dr. Peterson in the context of the code and expressed concern that a number of them appeared to be degrading, demeaning, and unprofessional. The panel observed that these public statements could undermine public trust in the profession and the college's ability to regulate it, and also raise questions about Dr. Peterson's ability to carry out his responsibilities as a registered psychologist. The panel noted that such comments may cause harm, both to the people that are directed at and to impact it in other communities more broadly. Dr. Peterson does not challenge the principles in the code. I kind of do, but that's okay. Although he takes issue with objections to his language on the grounds that some of it, at least, was justified based on facts, his response to the ICRAC recognized that he's made error in his public communications, already undertake remediation. See, I told you they'd use it as an admission. Right? It's like, oh, I've already made steps to correct it. They're using it as an admission against him. Of course they are. You can't appease these people, man. You can't appease these people. Because it'd be like, you admit your sin. The ICRAC concerns relate to public interest in members of the college avoiding the use of demeaning or degrading language. In the case law, the Supreme Court of Canada observed a regulator's interpretation of the public interest based on his expertise is owed deference. Similarly, in a different case, this court gave significant deference to expertise of a disciplinary committee to assess whether a member's conduct was relevant to their suitability to practice, as well as members of that committee, which include members of the profession, were well situated to assess harm to the profession, the public, and the reputation of the profession by the member's conduct. The ICRAC is made up of a majority of professional members. Deference should be also afforded to assessment of risk of harm to the public and profession in this case. Dr. Peterson complains that reliance on the code is misplaced in this case, whereas the college is, to quote his argument, operating at the very margins of a mandate, as he asserts his statements are not made in his capacity as a clinical psychologist, but are off-duty opinions, which, yeah. I mean, he's not seeing clients. These aren't happening in therapy sessions. So, right, I mean, that would make sense. He refers to statements in the code that personal behavior of a member becomes a concern of discipline only if it's of such a nature that undermines public trust in a discipline as a whole, or if it raises questions about the psychologist's ability to appropriately carry out his or her responsibilities as a psychologist. There are at least two responses to the submission. First, Dr. Peterson's statements are not personal comments made in conversations with friends or colleagues, but public statements to broad audiences. What the fuck? Indeed, Dr. Peterson references his vast following on social media and his best-selling books. The code expressly addresses public statements and prohibits degrading and demeaning comments made by its members when making public statements. Second, the argument that Dr. Peterson is speaking in his personal capacity and not as a clinical psychologist is undermined by his own conduct and statements. As the ICRAC observed, Dr. Peterson describes himself on Twitter as a clinical psychologist, although you said earlier it doesn't matter, but whatever. And he identified himself on that way on the Joe Rogan podcast. Indeed, as he's made clear in his submissions to the ICRAC, quoted earlier in these reasonings, Dr. Peterson sees himself as functioning as a clinical psychologist in a broader space, where he claims to be helping millions of people, as he put it, still practicing in that more diffuse and broad manner. In short, while counsel may argue that Dr. Peterson's comments are off-duty and outside his role, Dr. Peterson doesn't see it that way. To the contrary, representing himself as a clinical psychologist when expressing his views is important to him. It also adds credibility to his statements since, as a regulated health professional, he holds a position of trust and responsibility in society. But Dr. Peterson cannot have it both ways. He cannot speak as a member of a regulated profession without taking responsibility for the risk of harm that flows from speaking in that profession. Wow. High standards are imposed on the member of the College of Psychologists, who, like other members of regulated professions, take on responsibilities to the profession and to the public. As the Supreme Court of Canada has observed, the importance of monitoring competence and supervising the conduct of professionals stems from the extent to which public places trust in them. Even when off-duty, courts have recognized that members of regulated professions can still harm the public trust and confidence in their profession by their statements and conduct. As the British Court of Appeals noted, in part citing the Supreme Court of Canada, when a teacher makes public statements espousing discriminatory views, and when such views are linked to his or her professional position as a teacher, harm to the integrity of the school system is necessarily a result. A similar situation arose in Pittner versus College of Nurses, in which two nurses spoke out on social media and at a public gathering against masks and vaccines during the COVID-19 pandemic. Whoa, that was dangerous. Nurses speaking out against masks and vaccines? Well, we can't have that, can we? Both identify themselves as registered nurses. The College of Nurses, ICRAC, identified concerns with certain statements which were misleading and could spread dangerous misinformation. As this court held, given the statutory mandate, it was reasonable for the ICRAC to be concerned about applicant statements. As the committee noted in their public statements, both applicants identified themselves as health professionals. Ms. Pittner publicly identified herself as a nurse practitioner, and Ms. Alvino publicly identified herself as a registered nurse. This not only put the public at risk of being guided by false information, but also risked impacting the reputation of the profession. So yeah, can't have any wrong think during the COVID. Masks are bullshit. Vaccines are bullshit. That's the wrong thing. Can't have any of that. No. So you dared to speak out against the orthodoxy, you will be punished. In Pitter, the court upheld the ICRAC's direction that nurses be cautioned and attend the remedial application through SCRP. The teachers have to engage in the struggle section for all that stuff. Yeah. Okay. Many other professional discipline cases have involved situations in which a member's misconduct in their personal life or outside the immediate context of practicing their profession has nevertheless resulted in regulatory action. As observed by Judge Copeland, it is well established that actions of members of a profession in their private lives may in some cases be relevant to and have an impact on their professional lives, including where their conduct is not consistent with core values of the profession and or where there's need to be a regulated profession to maintain confidence of the public in the profession and not seen to condone certain types of conduct by its members. We can reach into your private lives. It's all good stuff. Like the legal profession, health profession recognizes limitation on free expression to maintain boundaries of civility and professionalism. As a member of the legal profession, I'd like to say, here, panels of college and psychologists, the ICRAC, an expert body, reviewed its code and standards and expressed concern that Dr. Peterson's public statements, insofar as they contain degrading and demeaning language, may be inconsistent with professional standards, which could undermine the public trust in the profession. And then we get to like one of the most Kafka-esque Orwellian headers I've ever read. This is like so disturbing to me as an American lawyer. This header alone just brings chills to my bones. Balancing statutory objectives and freedom of expression. It's a balancing test. It's a balancing test. Let's balance the statute with freedom of expression. Okay. Apparently that's what I'm doing now. Turning to the Charter, which ostensibly protects fundamental rights, the ICRAC acknowledged that Dr. Peterson's submission that his conduct on Twitter is protected by his right of freedom of expression and is unrelated to his practice of psychology. However, the ICRAC acknowledged Dr. Peterson's submission that his conduct on Twitter is protected by his right of freedom of expression and is unrelated to his practice of psychology. However, as the panel noted, while Dr. Peterson has a constitutional right to freedom of expression, as a member of the College of Psychologists, he is also obligated to maintain professional standards of the college, which includes ensuring any public statement made are consistent with professional standards, policies, and ethics currently adopted by the college. Well, that freedom of expression is looking real valuable right about now. This is especially the case where Dr. Peterson identifies himself as a member of the profession. It's so absurd, I want to cry. It's so absurd, I want to cry. Dr. Peterson submits this limited reference to his right of freedom of expression in the decision was not sufficient or proportionate balancing of his rights and the college statutory objectives. I disagree. It is clear from history and context of the proceedings, the panel was well aware of the importance of the value of freedom of expression and Dr. Peterson's position respecting it and appropriately balanced freedom of expression with the college's statutory objectives. Right about now, all I have to say is this. Right about now, all I have to say is this. God bless America, and God bless the First Amendment to the Constitution of the United States. God bless America, and God bless the Constitution. They would do it if they could in America, too. They've already tried to do it in America. The ABA promulgated Rule 8.4G to do exactly this to the legal profession. And pretty much every state told them to go to hell. And some states tried to adopt it and actually got sued and lost. People sued their bar associations and won because of how bullshit this is. They would try to do this in America too. And the only thing that's stopping them is the First Amendment. Canada has its charter, but apparently its charter is subject to these wonderful balancing tests. God bless the Constitution of the United States and the First Amendment and the founders who gave us this wonderful system of government. May we be able to keep it. Dr. Peterson submits this limited reference to his right of freedom of expression in this. We read that part. Earlier in the decision, the ICRAC noted Dr. Peterson's submission that his professional obligation and ethical duties must be balanced alongside his personal rights and freedoms, and the protection of freedom of expression is basic and central of any fair and free democracy, particularly as it applies to public debate and criticism. The panel also noted Dr. Peterson's reliance on the Supreme Court of Canada's decision, a defamation case which held that freedom of expression and respect for vigorous debate on matters of public interest have long been seen as fundamental to Canadian democracy. All Canada's laws must conform to it. Canada has a very different view of America of what a fundamental right is right about now. In correspondence with Dr. Peterson's prior to the decision, The panel had agreed that Dr. Peterson's right of freedom of expression was engaged, but all right, yeah, let's just take a shot every time they use the word but or however or any of its equivalents. But oh Lord. It was subject to his duty to the public and to profession to conduct himself in a way that was consistent with professional standards and ethics. At this point, I really wish I had kept a running count of the but however count that we could just increment as we go, because I like to know how often we're going to use that. The panel was also aware of the ICRAC's 2020 decision giving what we're calling advice. We're still calling it advice to Dr. Peterson, in which the panel of ICRAC had referred to the Charter's guarantee of rigorous debate and concluded that Charter protects Dr. Peterson's public pronouncements so long as, that's but by other names, by the way, so long as would be another way of saying but, he does not violate provincial or federal law, which he does not appear to do so in this particular instance. It was argued by Dr. Peterson's counsel that the 2020 decision, in referring to the guarantee of rigorous debate and concluding that whether Dr. Peterson's views reflect poorly on the profession is a matter of opinion and not fact, showed a greater appreciation of his right of freedom of expression and engaged in a more appropriate balancing than the 2022 decision under review. However, as noted, even in 2020, Dr. Peterson was warned about using unprofessional language, with the panel advising him to offer his opinions and comments in a respectful tone in order to avoid a more negative perception of the profession of psychology. This is some trash fire. This is some trash fire. Could you, I ask rhetorically, it's like, could you imagine a bar association writing this stuff? And then like, well, apparently in Canada you can, because they even talked about bar associations in Canada. It's like, geez, man, could I imagine like the Supreme Court of, well, maybe the Supreme Court of Virginia might try. The Supreme Court of Virginia one of these days might try to come after my license. If they could, right? The Supreme Court of Virginia might try to come after my license one of these days if they could. But the Supreme Court of Texas probably will maintain my license. I'm just glad I'm not licensed in Vermont or New Mexico, which apparently adopted Rule 8.4G wholesale, which is some bullshit, but I digress. Woof. Woof. And you know, if you get enough liberal judges and enough progressive judges, this could come to America too, right? Justice Stevens would probably do this. This seems like some Justice Stevens bullshit. I could see this opinion being written by Justice Stevens. Just take it name off and say it was written by Justice Stevens and call it a day. Yeah. You know, you get the wrong people in the U.S. Supreme Court, man. Yeah. The fact that the decision does not provide a detailed discussion of the value of freedom of expression does not mean the ICRAC did not appropriately consider of it. So there's no detailed discussion of the value of freedom, but it's fine. Yeah. Furthermore, the ICRAC should not be expected to do so. The ICRAC is essentially a screening body. It reviews complaints and investigations and, where appropriate, sends cases to disciplinary hearings for adjudication, in which case its decision is not subject to judicial review as the process has not run its course. The ICRAC, however, has other less serious options available to address concerns which may be raised by complaint or complaints, including directing the SCRP, which is not disciplinary. So when we make you do the malice struggle session, that is not an act of discipline. We're simply trying to help educate you and enlighten you. The ICRAC had effectively 3 decisions in dealing with Dr. Peterson's case: send the matter to discipline, do nothing, or direct the SCRP, the malice struggle session. By directing the SCRP, the ICRAC pursued a proportionate and reasonable option to further its objective of maintaining professional standards, which will likely have minimal impact on Dr. Peterson's right of freedom of expression. I wonder if I could get Dr. Peterson on this program to talk about that. That would be kick-ass. I wonder if I could get Dr. Peterson to appear on the show. That would be so cool. And talk about this and some other bullshit. I wouldn't even know how to go about reaching out to him at this point. Maybe I'll try to start a tweet. I mean, you guys can help me tweet at Dr. Peterson or something and see if we can get him on here. That'd be so cool. and we can talk about this bullshit. What do you think? What do you guys think? I've got 300 of you captive. I got 300 of you captive. Hold on, I'm writing a tweet. Talk amongst yourselves. Let's see. All right, let's see. Okay. All right, so I'm going to publicly tweet him. All right, so I'm going to do that. And you guys can help retweet me. And we'll see if we can get him to appear on channel, because that'd be cool. Retweet me, please. Great. Let's see if we can get Jordan Peterson on. That'd be cool. All right. Let's see. Where were we? Great. Going back. Okay. The iCracks decision does not prevent Dr. Peterson from expressing himself on issues of interest to him and his audience, doesn't it, though? Doesn't it? Rather, the decision is focused on concerns over his use of degrading or demeaning language, about which he was given advice in 2020. So it's tone policing and word choice. So you're allowed to say the same things just with different words, I guess. So you have to find just the right words, I suppose. Requiring coaching following apparently unheeded advice seems a reasonable next step, proportionally balancing statutory objectives against charter rights, which are minimally impaired, if they're impaired at all by the decision. So they don't even think his rights have been impaired at all by the decision, which is odd, but okay. Results in this case may be contrasted with the results in other professional contexts in which balancing professional public interest objectives against charter's interests of a member have led to what appear to be more serious impairments of charter rights. In a different case, for example, the Court of Appeal upheld a policy that required physicians to provide an effective referral for services they oppose on religious grounds, such as abortion and gender-affirming care. The court held that a policy struck the appropriate balance between members' religious beliefs and the public overriding interest in equitable access to legally available public health funded services. In a different case, the Supreme Court upheld the Ontario legal regulator's decision not to accredit a proposed law school which prohibited same-sex activity among its students. The court found the decision represented a proportional balance between the limitation on freedom of religion and the statutory objectives the law society sought to promote, including access to the legal profession, diversity in the bar, and prevention of harm of LGBTQ students. Wow. So Trinity Western wanted to start a law school. And they're like, we're a religious school. We're religious, so we don't believe in same-sex activity between our students. So we're not going to allow it. And they're like, yes, you do. So your freedom of religion has to bend. So you can't have a law school. Wow. Yeah. Accordingly, I'm satisfied the panel conducted an appropriate analysis, addressed first its statutory mandate, and considered Dr. Parter's charter rights to freedom of expression. Decision proportionally balanced the competing interests, protecting public interest in profession and communication by members of preventing harm while minimally impacting Dr. Peterson's right of freedom of expression. Good times. Good times. The decision meets the requirements of justification, intelligibility, and transparency. Dr. Peterson's counsel also made the decision to not satisfy the required standard of reasoning set forth by the case law by failing to engage with Dr. Peterson's explanations for comment at issue. I do not agree. The ICRAC identified language used by Dr. Peterson, which it was concerned was degrading or demeaning or otherwise professional, which we covered in before. And if that's what they consider to be degrading, demeaning, or unprofessional, man, I have some choice words for them. I think my odds of getting admitted to the bar in Canada are going down by every passing moment. I'm not sure Ian Runkle's character reference is going to be enough for me to get that coveted Canadian law license because, yeah. 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 I have doubts about my future as a Canadian lawyer. Yeah. This concern is entitled to deference. It was not necessary to engage in whether Dr. Peterson's comments were supported by facts or was his honest opinion, as the concern arises from the nature of the language used, not the validity of his opinion. We have no problem with his opinion, we just don't like the words he used that express those opinions. Again, Dr. Peterson is speaking as a regulated professional, which might be protected by laws of defamation, such as defense of fair comment, but that's not the point. Which I suppose is fair enough as far as it goes. I mean, different legal standards have different legal rules. So whether or not it's protected in a defamatory sense is not necessarily dispositive, right? You could do that in America just because just because it's not this doesn't necessarily mean it's also not that. So like you could have like for example, recently for Nate the lawyer, like the judge's decision was saying, okay, this isn't defamation, but it might be defamation by implication, right? So you have to look at these issues in every possible frame of light. So, yeah. Dr. Peterson's counsel also made the decision to not satisfy the required standard of reasoning for failing to engage with Dr. Peterson's explanations for the comment. I do not agree. The ICRAC identified language used by Dr. Peterson, which was concerning, was degrading or demeaning or unprofessional. We read that part. The fact that a complaint by a client against Dr. Peterson was unfounded does not mean the ICRAC should not be concerned when Dr. Peterson publicly described the client as vindictive. So a client complained against Peterson in some context. Peterson won. And so he described the client as vindictive, and that's just too far. Okay. There's nothing unreasonable about being concerned when a regulated health professional attacks a client or patient, regardless of what they've done. Indeed, the Joe Rogan podcast, Dr. Peterson referred to the client's reliance on him, noting she had felt abandoned by him when he closed his client's practice and stopped seeing her. Similarly, while Dr. Peterson's comment on poor children may have been sarcastic, you think? It was open to the ICRAC to be concerned about him making demeaning jokes. I'm about to lose my mind, aren't I? I can already tell. That's okay. Sarcasm is commonly used to insult, demean, and degrade. The ICRAC's concerns with Dr. Peterson addressing Elliot Page as her and by their prior name, as well as calling a city councilor a thing and a doctor a criminal, a term even Dr. Peterson has expressed some regret using, arose from language Dr. Peterson used, not from his personal views. So too with his negative comment on the appearance of the woman of the cover of Sports Illustrated and calling Gerald Butts a prick. On the face, the language related to professionalism concerns and was not necessary for ICRAC to engage with Dr. Peterson on motivation for making these comments. This is also dumb. It is, you would hope it was a little bit more. You would hope. maybe it's just me. Maybe it's just me. Maybe it's just my American sensibilities. Maybe it's that I'm a fan of Dr. Peterson. I have some reservations about him. I'm not like, I wouldn't say I'm like a cult member of the Peterson cult club, but I have a lot of respect for the man. I've read his books. I think they're good. I've listened to his podcasts. I've listened to a lot of his stuff. I've watched him I've watched him 4 times. I'm a fan of his stuff. I have some criticisms. I have some critique. I have some questions. As one does. But I'm a fan of the guy. So maybe it's that I'm a fan of the guy. Maybe it's that I'm an American. But you would hope that like the examples would at least create just the smallest moment of pause in your mind, right? You would hope that like what they would come out with him would be like, just the smallest flicker in your mind, for just the smallest second in your mind, would be like, maybe we should censor this before your more rational mind kicks in, right? Just the splittest of seconds where you're reading it and you think, okay, we should censor this, before you're like, wait a second. No, we shouldn't, because of every possible reason, right? Before like that pure instinctual moment, right? That pure instinctual moment, you would hope that you would get something that would be closer. And this is just like an absurd laugh. It's a farce. It's a farce. It's so far afield. Like, this is the stuff they're coming at with him. This is the weak sauce. And this is the stuff they find that is beyond the pale. It's crazy. It's insane, right? You could at least imagine in your mind, just take a second. You could imagine First Amendment protected speech that Dr. Peterson had said that somehow was so like inflammatory, so whatever, that it might, you'd think, okay, maybe this is unfitting for a psychologist. Maybe this is unfitting language. This rhetoric is unfitting. And maybe you'd at least think about it. You would think about it for some fraction of time. But this is like going out the filter the other way. This is a ridiculous farce. This is what they're coming up with? This is their best material? He called Elliot Page her and by their prior name. He called a woman a thing. He called a doctor a criminal. He said the woman on the cover of Sports Illustrated wasn't beautiful. He called Gerald Butts a prick. This is our case? This is our case that rises to the level that's like, it's time that we, need to back off that First Amendment freedom of expression concern. Whoa. It's like, maybe I don't agree with it, but maybe there's something here, right? But this is what they got? This is ridiculous. And they want him to undergo re-education for this? They want him to go under education for this? What the fuck is this? What the fuck is this? It's like, don't you want to like make a case that makes you think about it for half a second? It's like, I want to laugh in their face. I want to laugh in the college's face. I'm like, you've got to be fucking with me. You got to be fucking with me is my reaction. You got to be fucking with me. This has got to be pranked. Am I being pranked right now? Am I on film? This has got to be a joke. Right? This is what you got. This is what you're wasting my time with. But Canadian court over here is like, I see no problem. And what's really, really sad about it is I'm not sure the Canadian court is wrong. Because if the Canadian court is properly quoting the case law, and I'm going to assume they are because I have no reason to think they are not. If the Canadian court is properly quoting the case law, apparently this is the correct legal decision. At least as far as this court's concerned. Which might be some bullshit, but it's the law. Because apparently the law is, the College of Psychologists is basically one step away from being the king and can demand fealty. Apparently that's the law. Okay. This is ridiculous. We use someone's prior name. A prior name, incidentally, they've acted under. They have credits for. But okay. Rather, the panel focused on the harm from the language used. noting transparently and clearly its concern that potential harms including undermining public trust in the profession of psychology and trust the college's ability to regulate the profession in public interest. I know I said it before, and I'll say it again. At this point, Nick the Nose Rackets Rakita has to be really, really glad he's not licensed in Canada. I mean, holy shit, dude. Holy shit, dude. Wow. Okay. The scope and extent of ICRAC's reasons must also be considered in the context of its role as a screening committee. The stakes before the ICRAC are not as high as they are before disciplinary panels. As this court summarized, the reasonableness review is respected to result in the stakes of the decision. Where a decision has particularly harsh consequence to the individual, there's a higher onus on the decision maker to explain its decision. The corollary is that whereas here the screening committee requires remedial and education response, a reasonableness review permits less detailed reasons. As noted earlier, reasons must not be assessed against standard of perfection. They need not include all arguments, nor should we expect or require administrative decision makers to deploy the same array of legal techniques that might be expected of a lawyer or judge. This is especially the case for a screening decision in the making of a remedial order. The focus on sufficiency of reasons in the prior case law should not be inappropriately used as a tool to reduce deference. The prior case law that focused on the sufficiency of reasons should not be used as a tool to reduce deference. Wow. And respect for the role and decisions of expert administrative bodies have regarding the context in which the decisions are made and the consequences for the individual. And in the event, the ICRAC's reasons are transparent, intelligible, justifiable, and reasonable. The panel prepared a 10-page, single-spaced decision. It considered a mandate and engaged in a clear change of analysis that involved reviewing a factual background. It concerns with the language used by Dr. Peterson and his response to the panels. It considered the advice, again, we're calling it advice, which we're calling advice despite the fact it's clearly a mandate. It considered the advice provided to Dr. Peterson in 2020, the ICRAC suggestion that Dr. Peterson agreed to undertake the program of coaching, his refusal to do so, which if it's a suggestion, why would it matter, and ICRAC's reasons for rejecting Dr. Peterson's own coaching proposal. The panel considered the professional regulatory context, the governing rules, the impact of the charter, Dr. Peterson's unwillingness to acknowledge the concerns. Following transparency and coherent decision, the panel concluded reasonably that Dr. Peterson's behavior raised a moderate risk of harm to the public, which the panel had articulated in its decision, and concluded it was very concerned with the recurrence of risk in this case was high, and therefore concluded the change of analysis by deciding it would appropriate to the public interest by requiring Dr. Peterson to complete a SCRP to address his professionalism in the public statement. The application for judicial review is therefore denied. The applicant, Jordan Peterson, shall pay the college costs of the amount of $25,000 in apparently a 3-0 decision. So, fun and exciting. So that is all that, and that was released today. So John Peterson has to pay $25,000, which he will absolutely not pay because he's already said he won't. So, yeah. Well, that brings us to the end of the analysis of this case. So I think what's going to happen, people, is Jordan Peterson's not going to pay the money. Jordan Peterson's not going to pay the money. And the Canada's going to come after him and maybe hold him in contempt now and throw him in jail. Dr. Peterson will probably go to jail as a political prisoner before this is over, the way this is going. So, yeah. Yeah, so Dr. Peterson will probably be a political prisoner before this is over because he won't pay the money. He won't pay the money. He won't undergo the education. He won't do it. They're going to suspend his license and they're going to expel him, and then they're going to go after him for the money and they're going to throw him in jail. So that's a bright future we can all look forward to. Can't Dr. Peterson appeal this? I don't know whether he can appeal it or not, but I don't see any basis to appeal. I don't see any basis to appeal. Assuming the judges are accurately describing the law, and I have no reason to believe they're not. I have no reason to believe they're wildly misquoting the law. Assuming the judges are accurately quoting the law, there's no basis to appeal. So, I don't know whether he can appeal, but I don't see any appeal being successful. There's no grounds of appeal. None that seem obvious. Sounds like it came from the Ontario Superior Court. Yeah, it did. Ontario Supreme Court. Yeah. Yeah, it came from the Ontario Superior Court of Justice Divisional Court, whatever the hell that means, before Judges Blackhouse, Shabias, and Krawchenko. Can I chat with an expert in Canadian law? I can certainly find one. I'll see if Runkle wants to talk about it. I'll see if Runkle wants to talk about it. I don't know if this is his speed, but yeah. Gifts sent by Sandy. Thanks. Let's take a look at the gifts. Oh, I see someone gave me a note that Koberger just waived speedy trial. Color me shocked. Color me shocked that he waived speedy trial. Of course he did. So, yeah, this thing isn't happening in October. Lazarus is a member for 32 months. Thank you. Jules is a member for 10 months. Canada is a scary place. Thanks for last analysis as always. Sarah Silverman gave Canadian $10 to say as a Canadian, I'm utterly disgusted by the CPO. If he actually liked what he said, he would hail him as a hero instead of a villain. I hate to say it, but it's worse than anything. Crazy by Proxy is a member for 3 months. Crazy by Proxy gifts 5 gift memberships. Thank you very much. Wesley Hoke gifts 10 gift memberships. And then I think maybe gifted 10 gift memberships again. And all that stuff. Viva, I can't get Viva to respond to my phone calls or messages to save my life. So I would get Viva on, but yeah, Viva is hard to get. Viva's a hard man to get. He's very busy these days. Have I ever listened to Rex Murphy? I'm not familiar with the name, so I don't think so. Who's streaming? Someone's streaming. I'll redirect you if someone's streaming. I'm always happy to show someone else some love. Let's see. Is anyone streaming right now? I wish YouTube made it easier to redirect people. It's just so inconvenient the way they have it set up. You have to go into the back end. It's so inconvenient to do it. There's got to be an easier way. For those of you who haven't retweeted the pinned comment, if you could, I'd really appreciate it before we leave. Let's see. Law Talk with Mike. Do I send you to Law Talk with Mike and Solve Sit land? Or do I send you to Artie's Corporate Fiction, which is also Solve Sit? So your choices are Solve Sit or Solve Sit. Wow. That's depressing. I'll send you to Artie's way. He can use the subscribers. I'll send you Artie's way. All right. Well, I've been done for now. Please retweet the pinned comment if you can. Let's see if we can get Jordan Peterson's attention. If I could get him on this channel to talk about this case, that would be kick-ass. I'd love to. So if you could help with that, I'd appreciate it. So if any one of you could help, that'd be great. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye.